Start. The appellant and the respondent were married in the year 2003. There has been matrimonial dispute between the parties since the year 2006. A girl child was born to the appellant and the respondent on 9.4.2007 named as Aditi. The appellant filed complaint against the husband before various authorities, employer of the respondent as well as National Human Rights Commission, a petition for seeking restitution of conjugal rights under Section 9 of the Hindu Marriage Act 1955 was filed by the respondent at Bengaluru, where the respondent was residing. In the year 2008, the appellant lodged FIR against the respondent under Section 498A of the IPC, being case number 204 of 2008. In the year 2008, the respondent filed an application for seeking a decree of divorce before the Family Court Bengaluru, which was registered as matrimonial case number 3358 of 2008. 3.2. The respondent filed an application before the High Court of Jharkhand at Ranchi seeking anticipatory bail in connection with Kadma PS case number 204 of 2008, in which case parties were referred to mediation and conciliation to amicably resolve their issues. On 11.19.2009, the Principal Judge Family Court at Bengaluru granted ex parte decree of divorce dated 11.9.2009. During the pendency of the anticipatory bail application being number 518 of 2009, the parties amicably settled all their disputes before Jharkhand Legal Services Authority. A settlement dated 19.12.2009 between the parties was communicated to the High Court. As per the terms of the settlement, the respondent agreed to pay an amount of rupees 5 lakhs as permanent alimony to the appellant. Further, the respondent agreed to deposit a sum of 5 lakh rupees in the name of Aditi for her all-time maintenance. The appellant further agreed not to challenge ex parte divorce decree. The appellant also agreed to allow the respondent to meet their child once in every 2 months starting from January 2010. The High Court disposed of the matter in terms of the settlement para 3.3. The respondent alleging obstruction by the appellant in his visiting rights filed an application seeking custody of the child Aditi under sections 7 and 12 of the Guardian and Wards Act 1890 at Bengaluru. The said proceedings under Guardian and Wards Act were transferred to Family Court at Jamshedpur under order of this court dated 27.3.2012. The appellant filed written statement in guardianship case number 11 of 2012. The respondent made an amendment application before the Family Court Jamshedpur praying for an alternative relief for addition of a prayer in his application in guardianship case, that is, for directing the child to be admitted in any reputed residential / boarding school in India at the expenses of the respondent, which amendment application was allowed by an order dated 16.5.2013. The Principal Judge Family Court by order dated 31.3.2016 decided the guardianship case number 11 of 2012 It is to be noted that in the guardianship proceedings, the respondent has given up his claim of the custody of child and confined his case to alternative prayer, that is, direction to admit the child in a boarding school. The Family Court Jamshedpur in paragraph 41 of the judgment directed, thus, in view of the discussions made above, I come to the conclusion that minor daughter of the petitioner and respondent Aditi Vishakha Das shall continue in the care, custody and guardianship of her mother till she reaches the age of 11 years and shall continue to pursue her education from Jamshedpur along with her mother. However, the petitioner shall have the visitation right as is continuing since before, that is during the pendency of the case. However, the petitioner shall be entitled to the custody of the child for half of each vacation of the school where Aditi is or shall be studying, and for the first half of vacation Aditi shall be in the care and custody of her father, that is petitioner, and for the second half of the vacation she shall be under the care and custody of her mother. The vacations referred to above are the summer and winter vacations in every school. Further, Aditi, upon attaining the age of 12 years, that is, for the academic session 2019-2020, she shall be sent to a boarding school of repute where she qualifies and is able to get admission. The entire cost of such boarding school shall be borne by the petitioner, and once Aditi gets into the boarding school, then the respondent shall have the right to visit her daughter as permitted by the school calendar, but at the cost of the petitioner, and the petitioner shall pay such cost which shall include the travelling airfare and other expenses in advance. Issue number 5 is decided accordingly. Full stop. Over.